Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends. Hello again to some of you who were here a little while ago, and then we decided to come back. And cover some things and stuff that we did not cover last week. For one, we have a new dropping. What the duck? From the Commonwealth on the Karen Reed case. It is Commonwealth's motion, notice of discovery number 53. We're up to 53 now. So we got that to look at. Then we have the video of Aiden Carney's hearing from last week from Superior Court that we did not have available to us when we Zoomed the hearing, which I think was it was sometime last week, like the 17th, I want to say, right? Today is, for posterity, Saturday, December 21st, 2024. It is the winter solstice today. So we went over that earlier before. If you missed it, then now you know today's the winter solstice. 12/1/2/21. 1/2/21/24. So 3 more days and a wake up. 3 more days and a wake up until Christmas. For those of you who are counting, and for those of you who still need to shop and decorate the rest of your Christmas tree, like I do. We still have 3 more days and a wake up. No big whoop. We've done it in less time than that. So we have the video courtesy of Canton Community Television and Tim, who gave me a really nice copy of the video of the hearing that happened with Tim Bradel, Aiden Carney, and Judge Krupp and Cosgrove. That was, I think it was the 17th, right? And then what I realized we never did before, which we need to do, is we need to look at the original motion to suppress, which was the thing that was discussed at the hearing. And we never looked at the original motion. And the reason I know that is because I have it in my computer, but it's not redlined. So if you'd like to go over that motion, I think it's important to go over that motion because a lot of people don't understand what they were arguing about in court the other day and what is now going to be appealed. In fact, I believe that Bradel filed a notice of appeal because of the delay that the Commonwealth has had in hanging on to Aiden Carney's devices, lying about searching them, not searching them, and why that's important. And why that is important. So, what do you say? Good? Sound good? Tomorrow, for those of you who were with me earlier, tomorrow we're going to go over the Blake Lively versus Justin Baldoni lawsuit. It's fire. And I've just been notified by somebody in the know that Justin Baldoni has been dropped by William Morris, who is his talent agent, because it seems that Ryan Reynolds and Blake Lively are also represented by WME. So he wasn't winning that fight. So that's interesting. I want to do that tomorrow at noon. So make sure you hit the bell. Make sure you have all of your notifications set to all so that you will know and you will be here when we go through that something like 80-page lawsuit resulting from sexual harassment alleged by Blake Lively against Justin Baldoni on the set of It Ends With Us, the movie that so many of you have seen and we've talked about several times. So there's that. We'll do that tomorrow at noon. Make sure you have the bell set because I didn't set it up yet. And, thumbnails are like, I don't have time for thumbnails. And thank you to all of you who said earlier, we're not here for your thumbnails. We're here for you. And I'm like, yes, nobody cares about those thumbnails as much as I do because, they take a long time to do and stuff and things. So let's do the Karen Reed thing first because that is, that's just what I have up on my computer. And it seems like it's going to take less time than the Aiden Carney stuff that we need to look at. So here is the Commonwealth's Notice of Discovery, number 53, which hit the docket. What is that saying? December 20th? Oh, yesterday. So yesterday, this hit the docket. Let me see if I can get it bigger for you. Yeah, not really. Not really. Come on, man. Eh, eh. All right, here it is. It is that what it says? December 20th over there? Is that timestamp say December 20th? Looks like it. So this came out yesterday. Yesterday, they're already up to 53 discovery dumps. And remember what Hank Brennan said. He said, I'm going to turn over everything. Everything. You're going to get it all. Whether I think you deserve it or not, you're getting it all. So he's giving it all to them. I'm going to look to you guys for guidance on some of this stuff because I have no idea what it is. And it's silly to be speculating about what it is because we don't really know what it is. But I can give you my educated guesses as to what it is, except for the things that I don't know what they are. Here you go. I'm sorry, Kimmy. I'm not gonna pivot on a topic. We're on a mission. This is the mission. It's gonna be drama free. It's gonna be documents. That's what we're talking about. And that's what we're talking about. Okay, here we go. This is the Commonwealth's Notice of Discovery number 53 that they dropped just yesterday, always on a Friday. I thought maybe perhaps yesterday we would see the SJC decision on Karen Reed, but nope. I thought that would come out on a Friday, but it didn't. But what had happened was it just didn't. So here it is. God save the Commonwealth. Now save the Commonwealth. Now comes the Commonwealth. In the above caption matter and indicates that of this date, the following discovery and materials have been provided to the defendant through defense counsel. Number 1, copy of the Massachusetts State Police Report number 106, which is 2 pages long, dated December 10th, 2024. I'm going to look to you on this because I don't know what police report could be being turned over that was dated December 10th of 2024. If anybody has any ideas on this, let me know. And again, it's a bait. Again, he's saying bait stamp, not Bates. It is Bates. Cosgrove even knows that it's Bates. Anyone? What's cutting in and out? My mic is cutting out. It's okay now. All right, I'm going to refresh my browser. So just hang tight. Don't go anywhere. Hang tight. It could be my voice because my voice is shot, but I'm going to refresh the browser. Hold on a second. I'll be right back. Okay, how's that? It's like the silent movies. We're going to go through. Should I just end this stream and start a new one? Because that's pretty damn annoying. I guess when I refreshed it, it just muted it all of a sudden. Okay. Is that better? Testing 1, 2, check 1, 2, check 1, 2. Check, check, check. Okay. If you are not hearing me, you're probably behind in the stream. We're going to go back to 1. We're going to go back to 1. Okay. All right. For all of you who said my sound was cutting out before, I don't know if it was you, if it was me. It's not you. It's me. It's me. It's not me. It's you. It's my voice. Here's what's happening. You may be behind. Stop. Stop. Everyone says it's good now. Please stop. Please stop. I'm going to turn off the air conditioning and the heat. All of it. The air conditioning and the heat is going off. Okay. Back to 1. Here's what we're going to do. Here's the plan for tonight. We are first going to look at the Commonwealth's Notice of Discovery number 53 on Karen Reed. Stop it. It's not cutting out anymore. It's not. Scott, can you, are these people all behind that are saying, these people all behind? I know it is. It's like I'm talking to my teenager. Video and sound is breaking. All right. Let's just cancel this and we'll do this tomorrow instead or another day. What do you think? What do you think? Should I do that? Just cancel it and go do tomorrow instead? Waiting. Still waiting. Still waiting. Okay, now it's good. It's good. I don't know. If I look at the chat, it's really super annoying because everyone who's behind is like, it's not working. It's not working. It's not me. It's you. It's not me. It's you. All right, we're going to look at the Karen Reed Commonwealth's Notice of Discovery number 53. We're going to try and ascertain what some of this ducking stuff is here. What some of the ducking stuff is. Okay. Then we're going to look at we have, thanks to Tim at Canton Community TV, a fresh audio of the hearing of Aiden's that we only saw on Zoom last week that we got no video of. The only video that we got is when Mark Betterow came in on Zoom and said hello. So that was it. And then what had happened was what I would like to do anyway, if everyone is, satisfied with the way the stream is going and the sound and the audio and the video, is look at the actual motion to suppress on Kearney because we never went over that motion to suppress. And the reason I know that is because I have it, but it's not redlined. So I think people need a better understanding if what exactly the motion was and the appeal that was the appeal that was filed. Yeah, exactly. Oh my God. Piney was, you sound like you're in my kind of holiday mood. Bravo. Well, if you weren't here for the last stream that I did earlier, it was supposed to be a distraction stream. Distraction procrastination stream. I have a child who had a tonsillectomy yesterday, and there's a lot going on here. I was out of commission all day yesterday, most of the day today, playing nurse, and it's painful, and there is a lot going on here. But everyone wanted to come and see this, so again, if it's not satisfactory, I can just pull the plug on this and go back to my nursing duties. So that's fine. Rewind your ducking. Refresh your ducking browser. Okay. So done with the complaints. I'm like, finished. I'm finished. This too shall pass. Thank you. Thank you. Thank you, Melisa. Thank you. Thank you, Melisa. Okay. This was filed in the Karen Reed case. We're going to be doing 2 things tonight. Karen Reed case, Commonwealth versus Karen Reed, the re-persecution of Karen Reed. Then we're going to flip over to the Aiden Carney hearing that we watched on the 17th that we did not have the audio for. Okay. And then we're going to look at the motion that is being appealed. So there's that. Oh, you turned off Housewives to watch me live. Thank you so much. I feel very, very privileged and honored. Thank you so very much. Okay, here we go. So here's what the Commonwealth turned over. Hank Brennan turned this over on yesterday. Today's Saturday. Yesterday was Friday. Like Mary Poppins. Thank you. I have a bag as big as Mary Poppins too. You can pull a coat rack out of my bag. That's how much stuff I have in my bag. All right, here we go. They turned this over on Friday. Copy of Massachusetts State Police Report number 106, which is 2 pages, dated December 10th of 2024. Okay, December 10th of 2024 was only I don't know, 10 days ago. Would have been a week ago last Tuesday. So what happened that the Massachusetts State Police would have made a 2-page police report about on December 10th, a week ago last Tuesday, in which they attached Trooper Tully's notes. Wasn't Tully a lieutenant? I thought Tully was rehomed, number one. I have questions. I thought Tully was rehomed. I thought he was a lieutenant. Now he's a trooper? Where did he take a trip to? I don't know. Did he take a trip to Vermont? Oh, that's interesting. That's interesting, Furious. I didn't even think about that. So what happened on December 10th? Well, that's very interesting. Huh. You can go back to Landman later. I love Landman. That's what, oh, interesting. What the duck? Could it be a report for their visit to getting the dog info? I don't know, because look, this is MSP report number 106. But this MSP report number 106, like, it's the very end of the year. We're in December of 2024. Like, this can't be the Massachusetts State Police report number, because they've got to be a lot farther than 106 reports in for the year of December. I mean, for the year of 2024. Could it have been a wrong year if we remember they wanted Karen Reed's parents' phone records from 2002 instead of 2022? I mean, yeah, it could be right. I thought Tully was rehomed out of Norfolk County. I thought he used to be a lieutenant. Now it says it, Trooper Tully's notes. Does anybody have any? Scott McGinnis does. Tully was a lieutenant, and yes, he was removed from D.A. Marcy's Norfolk County Detective Group. Well, where is he now? Does anybody have proof of life on formerly lieutenant, now trooper Tully? Right. What was report number 105? So here is report number 105. And they're turning over in paragraph number 3, copy of identification documents of Chloe in reference to Massachusetts State Police report number 105, which is a 4-page report. I mean, means nothing to me. It doesn't mean that Chloe's alive. Identification documents could be what? Could be microchipping, could be licensure, because I looked up the town of Canton website, and according to their own animal control department, you have to license your dog every single year by April 1st. And if you don't, there's a fine. So, I mean, the way that it says identification documents of Chloe, what was report number 105? It doesn't even say the date of report number 105. It doesn't even say that they're turning over report number 105. Exactly, Samantha. Shouldn't their time be spent on proving their case instead of attempting to disprove some other theory? I would think so. So if report number 105 was something like the report of one of Chloe's prior attacks, let's just say from 2022, after Officer John O'Keefe was murdered, there was a police report wherein Chloe got loose and bit, I think, 2 women who went to the hospital, right? If there was a dog bite in reference to that, perhaps they had to show identification documents like licensing, which would show whether or not there was a current rabies shot, maybe, right? I don't know, maybe there's microchipping, that would be identification documents. Oh, what the duck? Could these animal documents be why Brian Albert was meeting the animal control officer in the parking lot? Did that happen December 10th? Because, I mean, look, just like if we started to use common sense for a change, right? Report number 106 would come after report number 105. If report number 106 is allegedly dated December 10th, report number 105 would allegedly be at some time before that date. Although I have a hard time believing that report number 105 would be only the 105th report during the year of 2024. I'm confused. Brian met with them. Yeah, me too. Wild man's mom. I'm still waiting for an accident report or crash report for what they claim is a hit and run. Yes. Oh, yes. Oh, yes. Oh, yes. Oh, yes. Oh, yes, we both reached for the gun, the gun, the gun, the gun. Scott McGinnis says, I doubt Chloe the dog still takes breaths. They're trying to find a stand-in. Somebody said, Calla Lily said, it was reported with pictures on Facebook about Brian Albert meeting the animal control officer. Was it around in or about that time of December 10th? Because look, it's only December 21st right now. So that would have only been like 10 days ago. I have questions. Was Trooper Tully demoted? Is that a Scrivener's error with regard to the date? We don't know because, all of these attachments are not included. They're impounded. So there's that. I don't know. This is confusion for a Saturday night. I know it is. And then number 4, for more to add to the confusion, is a copy of digital forensics analyst report of Jessica Hyde, 4 pages, which again, Bate stamp number is Bates, but nobody watches my show, I guess. So I know it is crazy to apply common sense and logic. So here, notice that the digital forensics analysis report of Jessica Hyde is not, they don't tell us the date of it. Are we to assume? Oh, you should never assume because you make an ass out of you and me, according to the Odd Couple, but that this is a supplemental report of Jessica Hyde because all of the reports from the first trial had previously been turned over. And Jessica Hyde was the one who said 227 didn't happen, couldn't have happened because of this, that, and the other thing. Hank Brennan wants you to believe that she's got decades of experience, which we know is not true. So was she asked to supplement her report? What do you think? Olivia, I think that's the second part of your comment with the Canton Animal Control Officer. So Olivia says, Brian Albert has sketchily met with the Canton Animal Control numerous times over the past 3 years. It's not a new development. It sure is deeply troubling and shady AF. Just my opinion. Well, I don't know. We don't know what's attached here, but it's curious to me. Anybody have any inside intel or information? Jessica Hyde. KBT BS report. It's got to be a new report. It's got to be an amended report or a supplemental report, or maybe she was given some more information. Because remember, she wasn't given, I don't know, Olivia, you know better than I do because this is way over my pay grade, these Celebrite type analyses. Wasn't she not given like the hash values and the other things that she should have been given? So I don't know. Why meet with them when they don't have the dog? I know. Why is Chloe not subpoenaed? Joanne says the Telly demotion is fascinating. Old Line Red says Jessica Hyde's an expert at word salad. December 10th. What was the telematics on the Lexus? But there wouldn't be a Massachusetts State Police report on that. That would be a report of the experts, right? And that was also, it was done in Texas. So there's that. No, they don't have to resubmit everything again from the first trial, as far as I know. I mean, I think that everything that's already been exchanged has already been exchanged. So I think They're just exchanging stuff that wasn't exchanged the first time. Chloe's been butt-dialing Brian. Marianne says Hank Brennan has nothing left of the 75K retainer, so he's got his poor paralegal doing all the papers. Doing all the papers. Hot Wheels coming in hot. 1210 MSP could be the new charges of A and B, assault and battery on CA, Chris Albert, Colin Albert. You're going to have to give me a little more information than that. I'm going to assume assault and battery is A and B. Hi, Cal. Merry Christmas. Miss you too, Cal. I know you sent me an email. I'm going to respond to you. I promise. It's been weighing on me that I haven't responded to you, but I will. Cal's an amazing moderator. So let me know. Right, exactly. Maybe they didn't turn everything over. Who knows? Carrie B, was there a report written for that? Possibly 105. Let's see. Let's see what Carrie B said so we can figure it out. Maybe. That Chloe was in Vermont. Bob Weir is in the house. What up, Bob Weir? You know, it's going to get stranger. So let's get on with the show. Let's go. Suspicious that they met in a parking lot. Anyone can see what happened that night, but they covered their tracks for a trial. Theory is that Hyde wasn't even given the whole extraction. Only Whiffen was, but they still held back the hash data. Exactly. Yeah. So what I'm thinking is, I don't know what this December 10th police report was, but if some of you are pointing to a new assault and battery, that's interesting. What I do not think is that these identification documents of Chloe is anything new. So remember in the Vanity Fair article, the Vanity Fair reporter interviewed someone who was bitten by Chloe back in 2018, right? I don't know if she was bitten by it or her dog was attacked to the point where they thought that Chloe almost killed the dog, right? And then there were some phone calls to this woman that may have been something like from Kevin Albert, maybe, or someone on his behalf that said, what do we got to do to make this go away? Right? What do we got to do to make this go away? Is this something they should have turned over the first time that they never turned over? Is this something regarding the police report from May of 2022? I'm talking about specifically number 3 and Massachusetts State Police Report number 105 right now. Something they didn't turn over the first time that they should have. And then these identification documents of Chloe could be microchipping, could be licensing, rabies shot, because you have to license your dog in Canton, apparently. People are saying, is Chloe still in witness protection? This is Glenn 62. Right? Maybe. And well, what's up with the date if they're not new? I'm saying number 3 specifically. Number 1 and number 2, it says it's dated December 10th, 2024. They conveniently leave out the date of number 3 and number 4. It's a mystery. It's like, we'll be thorough sometimes, but when we don't want to tell you the date, we're not going to tell you the date. So this comic is very funny. So I don't know. Masters of Criminology says Tully was transferred to Detective Investigative Services and would assist as needed on previous cases. He was moved out of Norfolk DA's office per the news reporting. Yeah, that's what they said, right? So he's assisting as needed on something that just happened 10 days ago, and he's been demoted from lieutenant to trooper? Or are these a whole bunch of Scrivener's errors? I don't know. Thank you, Love Your Life. I appreciate you. A lot of people have their own thoughts about typos and whether or not they're accurate. Lilhar Oak says, cross-examination of Nicole Albert asking, was I there for that? A sidebar is requested. Oh, right. Was I there for that when you told the prosecution where Chloe was? Sidebar was requested, something to do with Chloe and info not handed over to defense. That was in regards to number 105. That's a great guess. Right. Sue says, I think he's turning over things from the past. And then he's just renumbering them at will because that would not be the real number of the MSP report. Because aren't those reports dated something like the year first and then like the order in order which the reports are received throughout the year? Yep. These things just appear, people. Ask your report. Duh. You're very welcome, Jen Lee. You're very welcome. I know. I know, Lady Di. We all have to go back through these documents to figure out what they're talking about. Olivia, dog identification documents sound to me like discovery the Commonwealth was court ordered to turn over to the defense summer of 2023, but didn't. And then Coco spilled the beans at trial, right? And it took them all this time to finally turn them over? Maybe. Could be. People agree with you. I think so too. I don't think it has anything to do with like the whereabouts of Chloe now and we found Chloe and Chloe's alive. I don't think it has anything to do with that. But, I could be wrong. I could be wrong. Right. Number 2 is written. Looks like his name is Trooper Tully Notes. What the duck? Yeah, Lori Marie, I know. That's what I'm saying. That's what I'm saying. So there's that. Since MSP doesn't do reports for everything, maybe 106 is right, says Donna. American Nana says, what an idiot all the time. The defense kept asking for Chloe. Interesting that you can't prove dog bite matches. So bottom line, was there dog DNA on John O'Keefe? Well, no swabs, right? Yeah, no swabs. Olivia is brilliant. I agree. And she says he seems to be flooding the defense with a lot of duplicative, redundant evidence to look like he's forthcoming and to inundate the defense with discovery overload, drain her resources, right? And make all of us get on the internet and speculate about what this stuff is when we just don't know. Yes, she did. Nicole did slip up and say Lally. She said, I told the prosecution where the dog was. I told the Commonwealth where the dog was, just in case it would be needed for anything in the future. Mariko, minor rant. I'm still irritated. Bait has not been corrected to Bates. I know. So we really don't know what this stuff is. I think we can't speculate. We haven't seen the attachments, but if anybody knows what happened on December 10th, I'm all ears because that's the only thing that's dated here. My guess is that Jessica Hyde has amended or supplemented her report after perhaps being given some of the info she was not given the first time. I don't know. Identification documents of Chloe probably have to do with one of her bites, I'm guessing. That she had rabies shots and things like that. Chloe is a key witness. She definitely is. So there's that. Without any further information, I'm not going to sit here and tell you that I think that they found Chloe because I don't think that's what it is. I just don't. All right. If we're done with that, we're done with that. Now I need to test something out. So I need to know if you can hear the audio on this. So I will allow it. Oh, wait, hold on.
All right.
You hear the audio on that. Oops. Just give me a yes or no. Yes? You can? Oh my gosh, I'm so excited. Okay.
For the court numbers 3 and 4 on today.
Woot. Okay. But what I think we should do first, not to get you all excited and then take it away. That is the amazing video of the hearing from, I just saw myself glitch too. I don't know. It could be like YouTube. We're like breaking the internet, maybe. I don't know. Thanks to Canton Community TV. But what I think we should do first, because we never did do this, is read the motion to suppress the devices and the things found on devices that was made by Bradle. And this was made all the way back in September. And while we have watched hearings on it, we have not read the motion, and I think we should. Olivia says Jessica Hyde's tweets lately have been cryptic AF. I wonder if she's had a change in opinion. What? Oh, yes. Oh, yeah. I know you're going to make me look it up, aren't you? I will, because if you think I won't, you're wrong. That's interesting. I mean, if I can find it quickly, hang on. I don't know. I can't find her. I don't know if she's all right. I can't find it quickly enough, so I won't look at it. But let's take a look at the motion to suppress so we can find out, so we can understand why this is so important and why Tim Bradel, who I'm a big fan of, by the way, I'm becoming a big Bradel fan. Why he said when he came out of court the other day that it's time for Massachusetts to change the law because this is ducking ridiculous. And this has already been appealed, so we're going to talk about it. This was a motion that was filed by Bradel in September. I don't know if that, I think it might have been even before Betero was on the team. I think. I think it was, because I think the first hearing we covered on this was like September 29th. And I think this was filed like September 26th. Oh, wait, let me just go back to the docket for 1 second so I can give you the proper info. Oh, except it just clicks me out. I hate when they make me click on all the pictures of like bicycles or bridges or fire hydrants or that kind of nonsense, because like there's always a little piece of a bicycle that you miss. Come on, man. 2382CR. There's so many docket numbers in this case. Okay, so the motion to suppress was made on the 26th. That was the same day that there was a motion hearing. So we never went over the actual physical papers. That's what we're going to do now. Okay? Okay? All right, here we go. This is in the case of Commonwealth versus Aiden Carney. Motion to suppress and to restrain any searching of computer and telecommunications devices for unreasonable delay with memorandum incorporated herein. Now comes Mr. Aiden Carney by and through undersigned counsel, and hereby moves under the 4th and 14th Amendments to the U.S. Constitution, Articles 7, 12, and 14, as well as the collective protection of the entirety of the Massachusetts Declaration of Rights, applicable state and federal case law, blah, 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 that the search of his computers and telecommunications devices and any statements made by defendant in relation thereto be restrained, that any evidence derived be suppressed, and that any further searches be barred for unreasonable delay. Mr. Carney's background relevant to the seizure. Mr. Carney is an investigative journalist who owns, reports from, and operates a number of news outlets that broadcast over the internet through YouTube, Facebook, Twitter, and his own website and web pages. He live streams news, investigates serious matters of public concern, and often breaks stories before viewers' very eyes live on air. He offers pointed and unapologetic commentary to his viewers, which numbers in 6 figures and cumulatively reach into the millions. He protests, urges boycotts, engages in political hyperbole, satire, rhetorical confrontation, rallies his supporters in the field, chases down witnesses and investigative targets wherever they may be found, petitions the government for redress, and exposes corruption by government officials. He practices advocacy journalism and provides in-depth, well-sourced factual reporting, often accompanied by a call to action for justice and truth. Mr. Carney has recently focused his investigative reporting on a pending murder case in Norfolk Superior Court, Commonwealth v. Karen Reed. Ms. Reed has been charged in the 2022 death of her boyfriend, Boston police officer John O'Keefe. Mr. Carney has been an outspoken supporter of Ms. Reed and has frequently detailed why he believes Reed was framed. The case has garnered national attention thanks to Carney and his detailed series, Canton Cover-Up, period. Some of the devices seized herein contain anonymous tips and journalist source information on these very topics and information on the very same state troopers investigating him herein. He has been deprived of this information for 11 months in the course of the Reed case and has been severely hindered in being able to report and utilize the information granted. Keep in mind, this was filed in September. So as of September, it was 11 months. Now it's over a year because they were seized, we will see, in October 2023. Warrant history and facts supporting unreasonable delay. On October 6, 2023, the Commonwealth sought 3 warrants to search Mr. Carney's home, car, and person to seize any and all telecommunications devices they came across. The Superior Court, Judge Krupp, allowed the warrants in the usual ex parte manner, and they were executed on October 11th, 2023, after the arrest of Mr. Carney on the instant charges at his child's bus stop that morning. All right, I'm going to break to say, this is interesting. Judge Krupp, the same judge that we're going to watch in the hearing right after this, is the judge who allowed the search warrants. He signed them. And he's not going to remember this motion, and he's not going to remember apparently signing the warrants in the hearing. And remember, they also arrested Aiden Carney at his child's bus stop that morning. Remember also that in some of the Bettero letters, we were provided with text message exchanges between, I think, Tully, right? Tully, who was a lieutenant at the time, Kate Peter, and Tully, and maybe Mello, about what time his bus stop was going, what time he goes to the bus stop to perhaps effectuate this seizure and warrant and arrest. And it was Tully, I think, correct me if I'm wrong, was it Tully that showed up at the bus stop and did the seizure and went into Aiden's house and took all his devices? I think it was. Yeah. One of Aiden's kids was 6 years old and saw that happen, ducking cops. Remember, Krupp equals the judge you like. So, I mean, I thought he was kind of fair in the last hearing that we watched, but now I'm thinking maybe it was another judge also. Was it Judge Walsh? I don't know. I'm conflating all my cases right now, but I did like him in one of the hearings that we watched. It's difficult, and this is why I asked Tim to see if he could get me the video on this, because I knew that he was in the courtroom, but sometimes they don't live stream it. It's difficult to discern tone and demeanor by just listening to audio. It's almost impossible, which is why it was so important for the Karen Reed trial to be moved to a bigger courtroom so that half of the jurors were not staring at the back of the witnesses' heads. And so I really wanted to see the video of this hearing because a lot of people were really, really down on the judge. And I thought, let's take a look at the video and see if we come to a different opinion, because it's really hard when you're not listening, you're not watching the people talk and you're just listening. So it was Judge Walsh. That was good, right? We like Judge Walsh. Judge Walsh needs a promotion to Norfolk Superior, in my opinion. 1 second, I need a drink. Okay. The police seized a plethora of electronic devices from Mr. Carney's home under the authority to seize them granted in the aforementioned search warrants. I wonder who signed off on the search warrants. I wonder which MSP trooper. If it was Tully, if it was Proctor, I don't know. The affiant officer seeking the warrants to seize the items knew that he had to file further particularized search warrants to justify searches within the wholesale seizure. He acknowledged the same in the search warrant for the Holden, Massachusetts home, search warrant 2370, stating, quote, following seizure of the devices, I will obtain subsequent search warrants to narrowly tailor the search. Remember, refresh your recollection about Karen Reed. You need, or Brian Walsh, who allegedly cut up his wife, Anna. You need a warrant to seize the device, and then you need another warrant to search the device. Brian Walsh's devices were given back to him in 24 hours. They extracted the data and they gave him back his phones. And his Google searches were crazy. It has been over 11 months since the seizure of Mr. Carney's devices. Commonwealth Present Counsel recently pledged in open court and in its Taint team proposal, they're going to talk about that during the hearing too, served August 12th, 2024, that warrants would be sought after Taint team litigation. Okay, that motion was called Commonwealth's Motion for Examination of Digital Material Seized from Defendant pursuant to 3 search warrants issued on October 6, 2023. See page 2, first paragraph, quote, the Commonwealth will file the promised second warrant for search of items seized under this search warrant number after the court acts on the within motion. There is no reason to further delay the promised warrant or warrants even further pending a Taint team. In fact, there's no reason to waste more time and taxpayer money on screening teams, as the Commonwealth's extraordinary delay herein is fatal to their intentions to go through Mr. Carney's devices at this late juncture. Sounds reasonable to me. Mr. Carney did not consent to any seizures. Mr. Carney, through counsel, has also requested several times for the return of his devices or for the data thereon, and has been categorically denied, or, as recently, presented 10 months late with unreasonable demands for concessions in return for the data at some future date. See docket filing. Commonwealth's response to the court's inquiry relative to providing the defendant with copies of seized electronic devices, stating on page 2, in light of the passage of time between seizure and adoption and implementation of a search protocol, the Commonwealth has reconsidered its position, listing 4 unreasonable conditions for return of the hostage data. Oh, I like that. Hostage data. In light of the incredible delay herein, the Commonwealth is in no position to leverage concessions out of Mr. Carney in return for disgorgement of his own property. Bradle is quickly becoming one of my favorite legal writers. Instead, the court should suppress any future searches and immediately order unfettered return of all of Mr. Carney's seized property. Because, it's been a wicked long time. And you kind of did nothing, and you kind of sat on it, and Brian Walsh. In the course of the Commonwealth's seizure of investigative journalist Mr. Carney's electronic devices, the tools of his trade, as it were, undersigned defense counsel has made several overtures to the Commonwealth to obtain relief for Mr. Carney. Almost 1 year ago, on October 19th of 2023, undersigned counsel brought the legal duty of employing a Taint team to the Commonwealth's attention via email as follows. Quote, also, would you be willing to agree to the appointment of a Taint team to go through my client's electronics that were recently seized? He has First Amendment protection as a journalist, and the police have no right to search through unrelated privileged files and confidential sources and items. If they've already proceeded, I demand that you have them immediately cease and desist from any further examination. If you have any questions about this procedure, I suggest you consult with the Attorney General's office, who has policies regarding such matters where privileged information may be encountered during the search. parens. They appoint a team of individuals unrelated to the prosecution, end parens, as well as preventative medicine versus Commonwealth. And there's the citation for that case, should you choose to look it up. Please let me know your position at your earliest. XOXO, thank you, Tim Bradle. Commonwealth Counsel replied the same evening via email at 4:56 p.m., October 19th, 2023, stating as follows. Oh, my red pen. You know I love my red pen. Come on, man. Okay. I will not agree to any third-party review of the materials found in your client's electronics. I do not know how far the investigators have gotten reviewing said materials at this time. I immediately forwarded your email to the investigative team and left messages requesting a status update as soon as possible. And then at 7:28 p.m., good evening, counsel. I was just able to reach Detective Lieutenant Tully. Oh, see, he was Detective Lieutenant now. He's Trooper again. Questions. He's the only individual in possession of the electronics seized, and I can confirm that he will cease any further searches until this matter can be addressed by the court. He wasn't supposed to be searching it at all. Yo. You have my word on this as an officer of the court. Oh. Was this mellow all the way back then in October 2023? Was this mellow? Mellow yellow? I don't think they had a search warrant. They only had a seizure warrant. He should have been looking at it at all. And now that it's been discovered through the Betterow letters and other things that around this time and leading up to Christmas of 2023, Tully, Mello, not so confidential informant Kate Peter, and female ex-girlfriend / booty call / friend of Aiden Carney, Lindsay Gattani, all had like direct communications with each other's private cell phones. Yeah, they call me Mellow Yellow. I know, that's where I got it from. That's right. Yep. John says it's probably already been searched. Yeah, well, they found out that it was. Mm-hmm. And remember Proctor lied in his warrants. His warrant applications. When he told the court that Karen's phone was seized at 5:30 on January 29th, 2022 in more than one place, and said the same thing about the car in more than one place. It wasn't just a scrivener's error. It wasn't just a copy and paste job. I don't know if Proctor, I don't know who signed these warrants, but if anybody has copies of them, we'll love to see them. At this point, there was no further confirmation or denial or explanation of, quote, cease any further searches forthcoming, revealing whether devices were searched or not. November 8th, having in mind the legal duties imposed on the Commonwealth by the preventive medicine case, undersigned asked via email on November 8th of 2023, any movement on your position that he can't have his devices back and a mirror image taken of them for your use? I'm hoping Lieutenant Tully or your cell phone extraction expert can confirm that once mirror images are taken, there's no reason to retain the devices. Are you opposing the use of a Taint team to review the data on the devices? The Commonwealth reiterated its opposition via email as follows at 8:30 p.m. on November 8th of 2023. The Commonwealth will oppose any motion to return Mr. Carney's electronics until all open cases, including any appeals, are over. What? We will also oppose the appointment of a Taint team. Well, Mr. Mello, why is it that Brian Walsh's devices were returned to him within 24 hours and you say that you need to keep all of his devices until the case is over? All of his open cases are over, including appeals? What? Selective prosecution, selective enforcement of rules and case law on defendants in Norfolk County. Brian Walsh is in Norfolk County also. And Aiden Carney didn't kill anybody or chop them up either. In the last several months, the defense also requested a court order for return of the devices, but the court has been deferential to the Commonwealth on the point, holding its judgment. The Commonwealth, represented by new counsel, has also reversed its position at the 11th hour and has now agreed it is required to utilize a taint team. Oh, because now Cosgrove is on the scene. And now he's like, oh, yeah, we do need a taint team a year later. These delays and the deprivation of his property have greatly prejudiced Mr. Carney's exercise of his First Amendment rights and have severely impacted his ability to follow certain leads relating to public corruption. Do you think maybe they wanted to hold on to his devices so they could see whether he had any material on any of them? Like Tully? Like Marcy? Like judges? Like Proctor? Like the other witnesses that he's been accused of intimidating? Presently, almost a year has passed with Mr. Carney being deprived of his property, a delay that the Constitution will not countenance. All of the foregoing delay, stalling, needless deprivation of property, passage of almost a year's time, flip-flopping, and failures to act have unequivocally coalesced into unreasonable delay requiring suppression. Oh, such a wordsmith, Mr. Bradle, such a wordsmith. I mean, look at in this one sentence, he uses flip-flopping and coalesced. I mean, and countenance in the sentence before. It's so well done. Argument. Where a citizen's property is seized, the Fourth Amendment and Article 14 require the Commonwealth to act without undue delay. The Commonwealth retained the devices at issue far longer than the reasonableness requirement allows. Therefore, any evidence related must be suppressed. Any search must be stopped, and the items must be immediately returned. The Commonwealth indicated recently in open court that it intended to seek further warrants relating to its retention of the defendant's electronic devices. Footnote 1. Oh boy, that font is small. Hang on. The pledge to seek further warrants arises no doubt from the lack of particularity in the prior warrants, as held in Commonwealth v. Snow, which is a 2020 case out of Massachusetts. To determine whether a search warrant was proper in scope, we asked whether it described with particularity the places to be searched and the items to be seized. The dual purposes of the particularity requirement are 1, to protect individuals from general searches, and 2, to provide the Commonwealth with the opportunity to demonstrate to a reviewing court that the scope of the officer's authority to search property, the scope of the officer's authority to search was properly limited. Okay, although in the physical world, police need not particularize a warrant application to search a property beyond providing a specific address, in the virtual world, it is not enough to simply permit a search to extend anywhere the targeted electronic objects possibly could be found. For a cell phone search, such a limit is akin to no limit at all. Given the properties that render a modern cell phone distinct from the closed containers regularly seen in the physical world, the search of its many files must be done with special care and satisfy a more narrow and demanding standard. We have noted that at a minimum, the standard for the proper scope of a cell phone search must be restricted to whether the evidence might reasonably be found in the electronic files searched. That's a hefty footnote. Okay. The pledged still to be sought second search warrant is far too late. under state and federal law. Even a lawful seizure does not remain indefinitely, so without a necessary subsequent warrant. A seizure reasonable at its inception based on probable cause may become unreasonable as a result of its duration. Yeah, it's been almost a year when this motion was made. After seizing an item without a warrant, an officer must make it a priority to secure a search warrant that complies with the Fourth Amendment. This will entail diligent work to present a warrant application to the judicial officer at the earliest reasonable time. When officers fail to seek a search warrant, at some point the delay becomes unreasonable and is actionable under the Fourth Amendment. Although the Supreme Court has not dictated a bright line duration past which delays are per se unreasonable, it has required that courts weigh the nature and quality of the intrusion on the individual's Fourth Amendment interests against the importance of the governmental interests alleged to justify the intrusion. In performing this weighing, the courts must examine 1, significance of the interference with the person's possessory interest, 2, the duration of the delay, 3, whether or not the person consented to the seizure, and 4, the government's legitimate interest in holding the property as evidence. Here, given the high possessory interest cell phone owners have in their devices, lengthy delays cannot be tolerated in the absence of consent, particularly here where the tools of Mr. Carney's trade have been taken in a brazen and obvious attempt to silence him in his ongoing and successful efforts in exposing corruption. Here, this was the case they cited, US v. Laced, L-A-I-S-T. Here, the laced balancing test overwhelmingly favors suppression. The nature of Mr. Carney's interest in the items is powerful and should satisfy the balancing test. As a journalist who is stopped in his tracks and deprived of the tools of his trade, investigating ongoing corruption related to an ongoing murder case, he still waits for almost a year. The second factor, the length of the delay here, is extraordinary. Tolerance for delay when applying to search a computing device is especially low. When the police seize an individual's computing device, the weight of the person's possessory interest is particularly powerful. And that is from Laced, which is a case from the US Supreme Court from 2012. Or Second Circuit, anyway, 11th Circuit, 2012. An individual's possessory interest in a computing device stems not only from physical repossession of his property, but also from the privacy rights implicated in maintaining access to this information, to his information. The purpose of securing a search warrant soon after a suspect is dispossessed of a container is to ensure its prompt return. If anything, this consideration applies with even greater force to the hard drive of a computer, which is the digital equivalent of its owner's home, capable of holding a universe of private information. For cell phones, these possessory and privacy interests are at least as strong. And here, in this case, Commonwealth v. White, which is a Massachusetts case, they said a delay of 68 days is unreasonable. Although courts have allowed short delays in obtaining a warrant to search illegally seized electronic devices, and this is permitting a 9-day delay. This is a Commonwealth case from 2009. And another US v. Burgard permitting a 6-day delay. They have found even slightly longer delays amounting to less than a month to be unreasonable. See US v. Mitchell. 21-day delay after seizing a hard drive was unreasonable. Quote, computers are relied upon heavily for personal and business use. Thus, the seizure interfered with a substantial possessory interest. Here's another case. Fourth Circuit case, US v. Pratt, 31-day delay unreasonable after warrantless cell phone seizure. This reflects the understanding that it should not take police officers several weeks to begin applying for search warrants for the cell phones they seize. I mean, those cases are on point. And what was the longest delay here? 68 days? Here, the defense spoon-fed the law on taint teams to the Commonwealth via email. Oh, I love it, spoon-fed. and was erroneously rebuffed. The Commonwealth rejected multiple requests for at least the data which was discoverable under Rule 14 and due months ago, at or before the pretrial conference under Rule 14, footnote 2, which says, undersigned counsel has personal knowledge that the Commonwealth routinely returns devices after downloading contents. Counsel has another case in the Norfolk Superior Court where the same investigators seized his client's phone by alleged consent, downloaded it, and returned it days later with no limitations. Oh, that's fantastic. That's fantastic. Hey, Judge, personal experience here. You have another, these same exact officers took another one of my client's phones and returned it days later. Counsel also notes that the phone seized in the incident case from one Janelle Webb, charged with conspiracy, was taken and returned days later. The alleged consent in these cases is immaterial to the issue of whether the Commonwealth can return the data or the devices shortly after doing what it needs to do to seize the data. Whether the property is seized on consent or a warrant does not change their forensic capabilities. Rather, the Commonwealth rewards consent with the easy return of the devices and punishes, as here, the target who exercises his rights to demand a warrant by needlessly keeping the devices. This fact adds strongly to the calculus that the delay here is unreasonable. The Commonwealth rebuffed efforts to promptly have them set up a taint team, as was their duty, was obstinate and absolute for months and months, denying at first even the applicability of a taint team, and then reversing its position only after exceptional delay. All the while enjoying exclusive possession of Mr. Carney's important First Amendment protected data involving government corruption, some of which applying to the very investigators that seized it. A palpable conflict of interest. Here we sit almost a year with no taint team and no pledged warrants. These circumstances dictate an immediate order for the return of Mr. Carney's property. As to the third laced factor, consent or lack thereof, the Commonwealth may seek to cite to several cases in which long delays have been tolerated before searching computers, but each of those cases, unlike here, rests on a consensual seizure. Whether or not the person consented to the seizure weighs in determining the reasonableness of the delay. For example, in Lace, a 25-day delay was held reasonable where the defendant signed consent forms authorizing the search and seizure of his computer. In People v. Shinohara, the defendant again knowingly and voluntarily consented to a search. These cases are in opposite here, where there is no evidence that the defendant consented to the seizure. Without consent, such a lengthy seizure without obtaining the pledged warrants is not constitutionally permissible, especially in the face of Mr. Carney's status as a journalist investigating the very same law enforcement personnel that are charging and investigating him. He was deprived of his data and sources and rebuffed when his counsel demanded a copy so he could continue his exercise of a valid, important First Amendment function that contravened the personal interests of the investigators themselves. In these circumstances, the seizure is invalid and the items must be returned forthwith. Based on the length of the delay, Mr. Carney seeks suppression of any statements made, evidence seized as a result of any investigatory leads obtained, or any further fruit of the poisonous tree obtained by police. Fruit of the poisonous tree. Mr. Carney did not consent to the police entry or warrantless search, and no other person present granted such consent. Conclusion. Where the Commonwealth has delayed over 300 days in seeking its pledged warrant, delayed by wrongfully opposing a taint team for many months, delayed by depriving defendant of the data in the seized property, and delayed over 300 days regardless of the specific circumstances, and engaged in all of the foregoing wrongful and dilatory conduct, defendant Aiden Carney respectfully moves that the court suppress the statements and evidence seized due to unreasonable delay and any further illegal fruits acquired therefrom. Wherefore, Mr. Carney asks for the foregoing relief and for any and such other further relief as the court deems proper. XOXO. This is September 25th, 2024. It's dated XOXO, Timothy Bradel. And, oh, what had happened was, that is the motion to suppress.
Let's come up.
Oops. Oops. Yeah, they took it without a warrant. They didn't have a warrant to search it, and they delayed 300 days, and the case law is pretty clear on that. Regardless of how you feel about Aiden Carney, you should care about the Constitution in Massachusetts, and they can't just take your property without your consent, without a warrant, and then not even try and get a warrant. Maybe they had warrants to seize, but they didn't have warrants to search, and they said they never even asked for warrants to search for 300 days. But then it was found out in one of the federal letters that they actually did search it because they took some evidence from his phone to use in the prosecution of, or the persecution of somebody else. I think it was maybe like Michelle Littlefield, right? Correct me if I'm wrong. Did the Goodmans gift another membership? Thank you, Goodmans. Did I bite him? Did I bid him? Thanks for the 10. Naturopath. I don't know how to pronounce that. Naturopath here. I think you need to take a tablespoon of honey that is local, preferably wildflower. Thank you. Love you. Oh, you know what I have? I have this throat spray. I have it. I've got something for that. It's clear voice spray. So excuse me while I spray. I'll be right back. Wildflower honey, you say? People say Manuka honey is good too, but I don't know. Thank you. Thank you for your suggestion. Thank you to the Goodmans for hanging around for 3 months. Happy holidays. You are great. We are all patient. Nobody's patient. Everyone's very impatient. And a lot of people have, hard time around the holidays. So we have to try and excuse some people. Thank you, Lynn. How can the Commonwealth keep this up? I don't know. It's a great point, but we're going to watch the hearing now, and we are going to watch the hearing, and you're going to see what happened. We watched it on Zoom again, as you recall, but there was no video. So now we're going to see the video portion.
Is Aiden Carney, 23 CR 313.
Let me just rewind it a little bit. This is going back to last week, which was December 17th.
We continue with now session. Turn up your cell phones, please.
Turn up your cell phones,
Court
please.
numbers 3 and 4 on today's list. Come up versus Aiden Carney, 23 CR 313, 24 CR 43. Mr. Carney is present and represented by Attorney Tim Bradel, who's present in court, and Attorney Mark Vetero, who is present via Zoom. The Commonwealth is represented by Special Assistant District Attorney Robert Cosgrove. Matters on for various motion hearings. If the parties could please identify themselves for the record.
Good afternoon, Your Honor. Robert Cosgrove for the Commonwealth.
Okay,
Hello, Your Honor. Timothy Bradel on behalf of Aiden Carney,
already,
person for the record.
okay. Mr. Carney's here.
And
Good afternoon. And Mr. Bedrow, you're on Zoom, are you?
I am, yes, Your Honor. Good afternoon.
All right. Before we call this case, this is going to take a little bit of time. Are there any other cases that need to be heard today? Nothing else. Okay.
And he's wondering because there's so many people in the gallery of the courtroom. A lot of people showed up for this hearing. Also notice I think this is the same courtroom where Karen Reed's trial was, because you can tell by the wonky layout, right? Yeah.
All right. Is there a natural order to things here?
My thought, thank you very much, counsel. My thought, Judge, was that I filed a notice of interlocutory appeal on Your Honor's ruling on the suppression, and I filed in connection with that a motion to stay the Taint team procedure until the single justice can either accept the petition, deny the petition, refer it to the appeals court or the full bench, which I think would probably take, into about mid-January, Your Honor. and for the reasons that I cite therein. And I
Let me
certainly
read it. Just
Sure.
handed it to me just
Sure.
a minute ago.
And on that point, Judge, I don't expect.
Let me
my
just read
brother
it. Let me just read it because I'm going to.
Yeah.
Okay. So the motion that we just read together, the motion to suppress, was denied. It was just summarily denied. I don't even think they had a chance to argue it. I gotta look this case up again because they keep kicking me out of the Massachusetts thing, the mass courts thing. So now I gotta go back and find the number again. It's like a whole thing. It's like a whole thing. It was denied. I think it was maybe, I don't know if it was scrabbled on there. 2382. Or if he issued a written decision, because they don't make it easy to find some of these records. But apparently that motion to suppress that we just read was denied on December 3rd of 2024. So it just says endorsement on, and this hearing again was on the 17th. Endorsement on defendant's motion to suppress and restrain any searching of computer and telecommunications device. That's the one we just read. After hearing denied search warrant that issued on 10/6/23 authorized the seizure and search of mobile devices used by the defendant to commit the charged crimes. 2 of the devices were searched promptly and extractions have been turned over to the defense. Other electronic devices were not searched due to disputes about the propriety of arraigning a taint team in accordance with preventive medicine. I cannot find the delay here was unreasonable. Given the issues raised by defense about the need for taint team review, nor can I find the defendant has been prejudiced by the delay. Indeed, defendant has not even filed a motion requesting the return of any devices, nor has he filed an affidavit explaining how he's been adversely impacted. And that was signed by Judge Krupp and dated December 2nd. So that's what he's talking about. He's like, I'm filing an appeal on the denial of that motion, Judge. And P.S. in the meantime, you need to stay the taint team stuff because I want a decision on that first from the appellate court. So you're going to take a little time to read. And it's dark, so we can't really see his expressions because he's backlit by that window, which kind of screws up the lighting. But huge shout out to Tim at Canton Community TV for doing a great job in that courtroom. Yep. They said they filed an affidavit a long time ago, said Potsy.
Okay. Have you had a chance to take a look at this, Mr. Cosgrove?
I have it.
Okay. Is there an opposition to it?
Yes.
Mr. Bradel, I hear you on it.
Thank you very much, Your Honor. So, Judge, it's really just the balance of harms issue in your discretion that, the government is poised to further search through Mr. Carney's remaining devices, wherever they haven't searched yet. And, there's very important things in there. There's about, Mr. Carney has about 5 or 6 other matters in which he has attorney-client privilege communications in his devices. He has journalist source material. That's really the reason.
But I see, what, the next step is to get a taint team protocol. That's what we're going to do today.
Sure.
Either you have an agreement or you don't have it, and I'm going to enter an order.
Yep.
Okay, I haven't
We did
seen
talk
any,
about that.
I haven't seen any opposition from you to the taint team protocol proposed by the Commonwealth.
Correct.
So I assume there's no opposition and I should enter it. With respect to this motion to stay, all you're doing is seeking to stay the taint team,
Correct.
right? I see no reason to do that because the DA is insulated from receiving any of that. You want to go up, you think you have a meritorious appeal, you'll take your crack at it. And if it gets stayed by the appeals court or a single justice, it gets stayed. But you're no more harmed by starting on the taint team process than not.
I do have a response to that aspect of it, Your Honor, is that, there's some very sensitive journalist source material in these devices. We're not sure, we don't know, we don't have an inventory of what they've searched, what they haven't. But, my client receives source material from many people, and he is.
The question is, how are you harmed by starting on the taint team protocol, which is to have the devices searched for privileged material, and you'll give a list of keywords that have to be searched, and there'll be essentially two people that'll have access to the devices and the data before you do.
Well, we're harmed because you should have never denied that motion, because according to all the case law that we gave you from Massachusetts and the U.S. Supreme Court, even a delay of like 31 days is too much. So, Your Honor, it's been over a year. They haven't done a damn thing. They've been sleeping on this. And there's a lot of constitutional issues a lot of constitutional rights at issue here.
No one, including a taint team reviewer, should have access to a journalist's confidential sources, Your Honor. That's our position. These people are civilians, police officers who volunteer information, whistleblowers who give my client information about all sorts of people. And in this particular case, Judge, there's a very important issue at stake, which is that
That's what the taint team is for. That's what the taint team is for. The taint team is going to review these devices for that kind of information.
Judge, we've been asking them about a taint team for over a year. At this point, they've waived it. You cannot hold someone's devices indefinitely. There needs to be ramifications for this kind of behavior, right? I think so.
The question as to whether the taint team is set up for anything other than the attorney-client privilege, but you're going to give a list of names and sources or other things that you want segregated from the Commonwealth.
No,
that is to say, the
yes,
Commonwealth can't see, and that process ought to begin. It seems to me, and there's no harm in beginning that process. Certainly, no harm to your client or sources.
Well, Judge, the harm is that people have, given Mr. Carney very sensitive information. And here's the important part about these very same investigators that are going to look at his phone.
Like Tully. Tully's the one who had possession of it, and Tully's the one that he's investigating, right? Hello? Anyone? Is anyone listening? Hello?
That are going to try to look at his phone.
The
Yes.
proposal is retired Judge Macy and forget the other person, a person named Verino. I assume that neither one of them are involved in this investigation. Is that correct? So this material is not going to fall into the hands of the very police officers that you're talking about. It's going to go to the taint team.
They've already looked at it. Come on, let's be
Initially,
real.
and it's going to be controlled.
Let's be real. They've already been through it. Just like they went through Karen's phone looking for nudes. I don't think they had a warrant then. I don't know. If you don't think they were going through it right away without a warrant, and they still don't have warrants apparently because they're still sleeping on getting the warrants at all because of this whole taint team issue. I mean, listen, there needs to be ramifications. Bradel kept his cool a lot better than I would be able to, and this is great to see the video of it because you can just see it in his face. He's like, "Are you ducking kidding me? Are you ducking kidding me?" That's who it was. It was Judge Brian K. Walsh without an E, who was the judge in Stoughton District Court for the Richard Schiffer hearing. That's what it was. That Judge Walsh, needs to be promoted to Norfolk Superior. That's who should be hearing this. And Karen Reed's case. I nominate Judge Brian K. Walsh from Stoughton District to be moved up to Superior Court. All in favor, say aye.
Taint team is going to be controlled by the court, and you're at some point going to have to review the work of the taint team.
The problem is there's never been a judicial review of the journalist issue. There's never been a pronouncement from an appellate court.
So if there is any journalist issue, if preventive medicine's Taint team protocol covers First Amendment sources. We're going to have to tee that up. That is to say, it's going to
We're
have to
gonna
go
tee
to
it
a
up?
Taint team. You're going to have to specify who.
Now we're using golf analogies here. We're gonna have to tee it up. I mean, you can go up. You can see. You can try. You can try. I mean, I don't think your appeal's gonna work, but you can go. You can try. I don't know. I think the appellate court might reverse this.
Who the sources are, whatever else, whatever keyword we have to figure out, that's going to come before the court. The court's going to have to make a determination about whether that should or shouldn't apply.
I
Okay,
appreciate-
right now, you're proposing to have me adjudicate something in a vacuum. I have no idea if there's source material on there. I have no idea if there's anything on there.
It doesn't matter anymore because they've waited too long. Once you wait too long, you waive your right to go through any of it, and it should be suppressed, and as should the fruits of the poisonous tree. If you see something illegally and you search it illegally, everything that comes from that search and seizure should also be suppressed. That's what they call the fruit of the poisonous tree.
Okay, and
Mr. Carney has provided in past pleadings, Your Honor, an affidavit to that effect, and I can get that to you. It's probably buried, 20 documents back, but I'll get that to you. But there is an affidavit in the court's record about what's on these phones. And just while I'm on that point, Judge, we have asked for the phones back a number of times, and I can show you that too. But
They have.
I don't think it's determinative in your court's.
We've watched
in your
the
ruling
hearings.
about the suppression, but the idea here, Judge, is that,
That's what it was.
well, first of all, I appreciate you narrowing the issue to just who gets to see these source materials. Should a Taint team person see such sensitive things? Let's say a police officer that works with these investigators that are chomping at the bit to get into my client's phones. Let's say that investigator works
Yeah.
with these people and is
Like
a
Pelly.
whistleblower about certain misconduct that may or may not have been reported on yet, or it may have been reported by Mr. Carney already in a confidential way. It may be a future story. Whether that should be looked at by anyone else hasn't been litigated, Your Honor. And that's the part of this that's so important, that needs a full hearing. It needs review by an appellate court, that that these source materials are dangerous and sacrosanct. And
Sacrosanct.
Massachusetts, as I know you know, is kind of behind the eight ball on protecting journalist material. There's no statute. There's meager case law that I gave you last time. It's nonetheless, the First Amendment protects journalists.
There is no statutory journalistic privilege in Massachusetts the way that it is codified in most other states, like New York. We've talked about this a lot of times, 100 times, a million times. There's no off the record in Massachusetts. There's no journalistic privilege. That's why you just saw Judge Kearney hand over Boston Magazine's private off the record conversations of Gretchen Voss, her notes, her emails, the voicemails with Karen Reed. They were all just handed over to the Commonwealth because there is no journalistic privilege in Massachusetts. Again, I'll repeat for those who don't understand, the defense in Karen Reed's case did not oppose that motion. The motion was opposed by the attorneys for the Boston Globe, Boston Magazine, and Gretchen Voss. But despite their allegations that Gretchen Voss was being threatened and her family was in danger if she was going to be required to give over this information, that nobody would ever talk to her again, no sources would ever talk to her again, that her career would be ruined, Judge Kearney didn't care and is forcing Boston Magazine and Gretchen Voss to give over everything in that case. So it's about time that the law changes, and that's what Bradel is going to say. I agree with him.
The Pentagon Papers case, Your Honor, protects journalists. There's sort of a piecemeal quilt of protections. And I think it's about time, and this may be the case, where the SJC, the single justice, or the full bench can say, journalist materials need to be protected, Your Honor.
That's right.
We
It's
know
time.
that attorney-client things are not quite as sensitive in terms of somebody putting their career on the line, putting their life on the line to give information to a journalist.
we don't know that for a second.
Oh, oops. Yes, we kind of do. Hold on. I got to see where I was in this. Because I just made it go backwards by accident. Where were we? Yeah, we kind of do. We kind of do know that. And right, wouldn't it be so ironic, don't you think, if Aiden was the one who changed that law? If he was the one who made case law in the SJC of Massachusetts that all of a sudden they're going to enact a journalistic privilege. That would be so ironic. Let me just see where we are here.
Possible to give keywords about source.
Yeah, we're past that, right?
What I would ask, Your Honor, is that you give us a little more time,
Right.
but there's an implicit, any communications relative to the attorneys and
Yeah.
I think they will do that. Those source materials and attorney-client privilege materials will be protected through the Taint team protocol.
We're about to get to the Taint team protocol.
Okay.
We're about to get.
Wait, let me go back. Where's back before that, right? Yeah. Sorry, guys.
Somebody putting their career on the line, putting their life on the line to give information to a journalist.
We don't know that for a second.
Well, it could go either way. That's really more to the point, isn't it? That we have to figure it out. And, you know, people risk their jobs, people risk everything to blow the whistle on corruption. And that's what Mr. Carney receives time and again. And his track record, you know, you may not like it from one perspective, but from another perspective, I know you're a fan of the First Amendment, and Mr. Carney has an unmatched track record of scoops, of revelations, of uncovering corruption. That's why he's sitting here, Your Honor. So these are incredibly important issues that to ask for 30 days to have a single justice evaluate the same arguments I'm making to Your Honor is really not a ton to ask. You know, it's just some time to allow me to get the brief to the single justice, let my brother respond, and let's see if we can actually generate some important case law, some appellate precedent that can give us some guidance on what to do in the situation and to give some protection to journalists.
All right, let me hear from Mr. Cosgrove.
Just two brief comments. One is it may be that an affidavit setting forth all of this has been filed somewhere and I missed it. But my memory fails me as to seeing this so far as I recall. These have just been representations of counsel who I assume have not been through Mr. Kearney's materials. The other thing I would say is this is not a promising interlocutory appeal by the usual standards.
Okay, well, I'm not really going to trust your opinion on this because you can't even remember seeing the affidavit and you're taking over from Mellow Yellow that nobody has proof of life on yet. But we're going to hear about where Mellow Yellow is at the end of this hearing. But your opinion about the whether the appeal will be successful or not is not really relevant here.
One of the most significant factors is whether any harm can be remedied in the ordinary course of appeal. And of course, we know that if there's a failure to suppress something that should be suppressed, that's classically something that can be remedied in the ordinary course of appeal. So I don't think, candidly, that Mr. Bradle's chances of the interlocutory appeal are particularly good. And for the reasons Your Honor has articulated, I don't see that we lose anything by going forward on the Taint protocol, because we're talking about, frankly, a several-month process before anything is even turned over to the Commonwealth. I would suggest that Your Honor deny the motion. I'm happy to hold off for 4 or 5 days. If Mr. Bradle wants to appeal Your Honor's denial of his motion to stay to the single justice to give you time to do that. But I think the proper action is to deny the motion.
For the reasons stated previously, I agree, and I'm going to deny the motion for further, to stay further search pending interlocutory appeal.
Right. They've had 14 months, but you can't have another 30 days. So sorry. Too bad. So sad.
Judge, just so I have it right, your position, you're holding, your fact-finding, Judge, is that those source materials and attorney-client privilege materials will be protected through the Taint team protocol.
We're about to get to the Taint team protocol.
Okay,
We're about to get to it.
all right.
I endorsed the Commonwealth's revised proposal for examination of digital materials, docket number 53 in docket 23313, back at the beginning of this month, that the court will take up this motion at the hearing today, 12/17. The parties will discuss the proposed protocol in an effort to resolve any differences before the hearing. Any opposition to this revised protocol shall be filed by December 13. Did you file an opposition?
No, Your Honor.
Okay, so I should adopt this proposed protocol?
Your Honor, we have,
Did you discuss it with Mr. Cosgrove
we did, excuse me, sorry, we did,
after the last hearing?
yes.
Okay,
So we talked about, or I raised 3 issues, Judge, that are not covered by the government's proposal. The first was that whether other privileges would be honored by the Taint team through keyword searches, and I think they will do that if we're giving keywords to them that involve journalist privileges and so on and so forth. Obviously, it's impossible to give keywords about source materials without ringing the bell. So, you know, that's a,
the keywords are disclosed to the court, right? And the court's going to provide them to the Taint team under this protocol.
right, so you can see how problematic it is that there be generated a list of keywords that are potentially related to source material. So, you know, that's one of the issues that we object to. The second issue that we want to deal with is that the government is specifically excluding from potential search terms the any communications relative to the attorneys in the Karen Reed case. And we would object to that, Judge.
Because there's an attorney-client privilege between the attorneys and Mr. Kearney?
Well, there's a joint defense issue, Your Honor, that they're both.
So it would predate any jeopardy to Mr. Kearney. So communications with them predating any jeopardy to Mr. Kearney would not be covered by a joint defense. It would only be after Mr. Kearney was charged that there would possibly be a joint defense,
Well,
right?
it's a little more complicated because we know that he was under investigation along with Ms. Reed without any resultant charges.
Oh my God, somebody's phone just went off. Somebody's phone just went off. He's arguing here that any communications between Aiden and Yannetti Jackson or any of Karen's attorneys should be also protected because the Commonwealth tried to indict the both of them for conspiracy of witness intimidation and failed. And without knowing how long that investigation was going on, they would have been co-defendants, but didn't work out. He's arguing that those should be subject to the Taint team review as well.
So we would contend that does fall under the umbrella.
Hang on one second.
Oh, Judge is not having it. He's like, whose phone was that?
Okay, go ahead.
Turn up off your
We
phone.
would just contend, Judge, that the Karen Reed issue is a live question, whether or not there's a joint defense umbrella on that.
Do you have a joint defense agreement?
We don't have an agreement, but there's an implicit, there's been an ongoing, long-term implicit mutual assistance and mutual defense that I myself have been a part of for a long time, and Attorney Bedro has as well. And it's an issue that is not able to be worked out.
I really have no idea what that means. Are you asking me to make any particular, let me ask you, on the first issue, are you asking me to make any changes whatsoever to the proposed protocol? I'm looking at the motion, which is docket number 53, indented paragraphs numbered 1 through 10 on pages 4 to 8 of that document.
Judge, what I would ask, Your Honor, is that you give us a little more time.
No,
to
today is the day.
No.
Today, we're doing the Taint team. I specifically ordered it 2 weeks ago. If you wanted to submit an opposition, you could. You didn't. So I'm going to act on this now, and I'm bending over backwards to accommodate you here, not having filed an opposition, and I'm hearing you on any potential changes that you are suggesting need to be made to this protocol.
Well,
But
Judge,
I'm not hearing any specific ones,
we filed a motion to stay.
and I denied that.
Right.
So the next
So
question is,
I am now asking for time to respond to some of the more detailed issues.
that's denied. Okay, I set a schedule for dealing with the protocol 2 weeks ago, and it was to do it today.
All of a sudden, everything's a rush. All of a sudden, everything's a rush. Of all the hearings that we've watched, we've seen like a couple of different judges on this, right? It seems like the judge changes every time. Except for that, this was the judge who actually signed the warrants for the phones, or, for the bus stop. And he's been on, I think, the hearing before this. There was Judge Katie Rayburn was on one of these hearings, I recall. And we did like her. She seemed to be very fair. This is kind of like, I mean, I don't think a 30-day delay here is asking too much, but apparently the judge did.
So, hearing no specific proposed changes to this, I will adopt the proposed protocol. I'll need to get a copy of it in Word form so I can adapt it into an order. So if I can get docket number 53, maybe I already have it in Word form in some email someplace, but I'm going to need it
I'm sure I
in
can
Word
submit a
form.
copy to the
Okay.
clerk.
Okay. There was a motion to compel Rule 14 discovery that was filed by the defendant, and 2 weeks ago I entered an order that required the parties to confer about that and to let me know in writing by last Friday if there were particular requests that were sought. I don't believe I saw a letter requesting any additional discovery.
We have conferred on that,
Okay?
Your Honor. Two things. I did file a motion for a protective order with respect to some discovery responsive to that I'm prepared to,
So I got the Commonwealth's notice of discovery on December 10,
right.
and there was a motion for protective order regarding communication produced in the Commonwealth's notice of discovery of December 10. That's how it's captioned.
Yes.
And I signed that back on December 10.
Oh.
Is that what you're referring to? Maybe it wasn't docketed in the signed form, I don't know.
I think it probably wasn't docketed.
Let me just give this to you and make sure this is the right document that you're thinking of.
It sounds like the right thing. Yes, thank you.
There is something docketed as docket number 55.
Did you receive a copy of this, Mr. Bill?
Yeah, that was the protective order. We went over that on another stream.
No, I don't believe so.
All right, so you folks can take a copy of that today. We'll get a copy for you.
It's probably a flaw in the way they filed it. So in any case, I'm going to turn all that material over to Mr. Brady.
Okay.
I'm aware that the court has executed the order. Thank you. There is additional discovery involved in terms of the search of the iCloud for the district attorney's records, and search of some of the employees of the district attorney's office. which is in progress at the moment with Karen Reed team. I have conferred with them and will provide them with additional search terms that are specific to this case. Most
This
of
is the so-called Proctor discovery?
Yes,
Proctor
and
discovery.
also some of the other offices that are involved. And most of the search terms will be identical to those that the Reed team is using, because with one or two exceptions, the alleged victims on the indictments that are before Your Honor are the witnesses in the Reed case. So it comes out to the same thing, but there are a few additional names. I'm going to submit that. Once the search has been done, I will review all of the documents and turn over all the Rule 14 material to my brother. I expect that's going to take probably another 3 weeks.
Okay. And you have a date in January for another hearing
January
on
10th.
the issue with respect to Mr. Mello.
Yes.
Okay, listen up.
With respect to that, Your Honor, I have to tell the court that I don't think Mr. Mello's health is going to permit him to attend that hearing.
Remember, that was the day they were going to call Mello as a witness and have Mello testify about this stuff that was going on between Mello, Tully, not so confidential informant, and Lindsay. They were going to put Mello on the stand. He was a witness. And now they're saying, oh, he's not going to be able to make it. He's too sick.
So I don't know what Mr. Breda wants to do, whether he wants to try and go forward without Mr. Mello, whether he wants to get another date, or whether he wants to use it for some.
How about maybe we get his deposition now if he's that ill while he's still among the living? I don't know. Has he been rehomed? How about we have him appear by Zoom from his hospital bed if need be? That's commonly done. Defendants are arraigned very frequently from hospital beds. Can be done.
These other issues that
Is this your motion, Mr. Brado? I don't think I went back and read that motion. What are you seeking to do?
Yes, there's a motion to disqualify Mr. Mello for a host of reasons, Your Honor. And that's been pending for a long time. So
When did you file it?
9 months ago, 6 months ago.
Okay.
And then since
And
my
it's,
file,
and it's opposed?
yes.
And, but Mr. Mello was not able to get here and is somehow impaired,
That's correct.
okay?
I don't know. Should they have to improve?
All right.
Shoot. Should they have to like prove that he's impaired? Keep doing that.
Involved in the trial?
Trying to go forward without Mr. Mello, whether he wants to get another date, or whether he wants to use it for some of these other issues that we've got.
Is this your motion, Mr. Brado? I don't think I went back and read that motion. What are you seeking to do?
yes, there's a motion to disqualify Mr. Mello for a host of reasons, Your Honor.
Right. We went over
And,
that.
That's been pending for a long time. So
Yeah,
when
the
did you
motion to
file it?
disqualify him because of all these things, because he's involved with a not so confidential witness and Tully and the Bedero letters and all of those other reasons.
9 months ago, 6 months ago.
Okay.
Shouldn't they have to prove
And
that he's
then,
in poor health? I
and
don't know.
my
I
file-
think
It's
so.
opposed?
Yes.
And, but Mr. Mello was not able to get here and is somehow impaired.
That's correct.
Somehow
Okay.
impaired.
Um,
We shouldn't have to prove it, I think.
Since my
Do
original.
do you
file-
expect him to try the case? Or that he would be involved in the trial?
A lot depends on his prognosis, right? So at this point, I could not say one way or the other.
I don't know. Maybe since
Whether
then.
Mr. Mello is going to continue, whether the district attorney is going to find another person, or whether I'm going to wind up doing it. I couldn't say it at this point. I'll only tell the court that I'm proceeding as if I'm going to be the trial attorney.
We said he's going to be trying the case.
Why does it matter to you whether he's disqualified?
Well, he's a witness.
What matter?
We originally filed a motion for other reasons,
He's a
and,
witness.
they're readily apparent in the record. I think it's just going to belabor the hearing to move into that. part two of that, as that motion was pending for months and months, it became apparent that Mr. Mello is a witness in the case. And he's been communicating with the complainants on his cell phone exclusively. And he's definitely going to be a witness. We filed again papers to that effect. That's part two of the disqualification motion. That's probably the low-hanging fruit on it, the easy way out, is that he's a witness. And
Okay.
You can see the frustration in Bradl's
Hearing
face.
on for January 10.
at a minimum, we can address some of the other issues that are coming up in terms of discovery on that date, Your Honor. And if maybe, who knows? I don't know what his health situation is, Your Honor.
Well, we have 2 weeks in that, where very little is going to get done at the end of December.
Hmm.
Does that give you enough time? Does that give the DA's office enough time to deal with the iCloud issue and the documents with regard to others in the DA's office?
I think I'm going to need 3 weeks anyway.
Yeah.
I think we'll have some business to attend to that day if you want, Your Honor. We'd like to just kind of keep the ball rolling.
We can leave it on. We can leave it on. We may have things to discuss about the Taint team's work, because if I enter this order today, we're going to have to figure out things like, has it been abided by? So we're going to need stuff from you to make sure that the Taint team process works, and there's a schedule for that.
Your Honor, if I can just backtrack for a second. I filed that motion under the optimistic assumption that it might be acted upon the last time. And I think there is a date in there for
You're a little optimistic.
compliance in one aspect by Mr. Bradle that will have to be amended. I'm sorry.
The Rage Crochet Club is in session.
I take that back. I was thinking of the motion filed subject to the
Okay.
so I'll say
Yeah, I don't see any dates. All the dates that are in the Taint team protocol proposal all seem to be keyed off of the date that the order is signed.
Very good.
Okay? All right, you're on for the 10th. Anything else?
Yes, I'd like to be heard on the motion Mr. Bradle requested the last time when we were heard on the sidebar. I'd like to be heard on the sidebar again. And,
More sidebar.
and ask that conversation begin.
Right, Kate. Mello's healthy enough to run an illegal sting operation against Aiden, but no court. Right, and he made himself a witness by doing that. Donna, Mello was the
This is the request to vacate the court's order of September 27.
Right, and adopt when we propose it.
Okay. All right, I'll see you at the sidebar.
The sidebar. It's like the sidebar. Mello is the assistant, specially appointed assistant district attorney that was hired to prosecute Aiden Carney
Anything else today?
before
I
Cosgrove
think
stepped
that's
in.
everything in Commonwealth will be covered.
Okay,
been
Mr.
missing.
Bradle, anything else?
I'll say.
Okay, thank you.
We'll see you January 10th at 9 a.m.
All right, so they're coming back January 10th at 9 a.m. Thank you to Canton Community TV. Now let's take a look just at the docket for a second, because here is what has happened since then. Bradle filed a notice of interlocutory appeal to appeal that ruling on that motion that was denied to suppress the fruits of the poisonous tree, aka the phones, based on the fact that they still haven't searched them. The defendant's motion to stay further search pending the interlocutory appeal was denied by the judge. And then the Commonwealth on the 20th, so that was the 17th that we watched that hearing. On the 20th, the Commonwealth filed a motion to submit a flash drive exhibit for motion to vacate the court's order of September 27th, 2024, in light of its manifest ineffectiveness, and impound the motion and flash drive exhibit filed. So was that some of the text messages or emails of Marcy that they started to turn over? That was what they just discussed at sidebar. If anybody knows, let me know. And then here, this is interesting. On the 20th, others motion to impound letter. So it's like someone else filed a motion. And others letter to Judge Krupp and letter from the Office of Bar Counsel. Those are interesting, but we can't access them. So I don't know what they are. I guess this is a motion to impound these two letters, the letter to Judge Krupp and a letter from the Office of Bar Counsel by other, which means a person who's not a party to this. So that's interesting. That's what you think? It's LG? I don't know. But did you find it, if you watched the hearing with me on Zoom, which we didn't see, there was no video at all, and what we just watched on video, did you think it was better to watch it on video? Did you understand it a little bit better? Do you think it was better to understand that? So you think LG is the other, Lindsay Gattani? Interesting. Interesting. Thank you, Bell, for the 10 and tuning in from Canada. And Amber C, wish you and your family a very Merry Christmas as well. Thank you so much. Sharon says, Yarn is at the hospital. No energy, though. Hope you're okay, Sharon. I hope you're okay. Scott says, a Special Prosecutor Cosgrove is a retired Massachusetts judge, reanimated like a zombie to take over for Kenneth Mello, do all DA Marcy's dirty work. Thank you. Thank you, Sherilyn, for the Cash App 5. And for introducing me to a new case is what it looks like here. To the person who said, I'm coming in late. I spent time and money on this channel. I'm getting pissed off of Melanie screaming at her followers when they try to help her by telling her she's cutting in and out and get yelled at for it. I'm not even going to give you the shout out of your name, but I'm here to tell you that when people are behind in the stream and they can't stop putting it in the chat after I've seen it 45 times, it gets a little annoying. Really so sorry to offend you. And then this person who I will not shout out either. I have a hard time comprehending your tone. I believe wholeheartedly in Karen Reen's innocence, but your snark is off-putting. Some people come here for the snark, I'll just say. And also, my snark is in relation to the constitutional rights that Massachusetts seems to think that you are entitled to have your constitutional rights trampled all over. So that's where my snark comes from. I live in New York, so it I don't give a duck about it, but I really do, because you know what? A lot of my viewers are from Massachusetts, and I give a duck about the Constitution. So that's where my snark comes from. I feel like whether you like Aiden Carney or not, he's a journalist and his sources should be protected. His devices should be protected. If a serial killer, not a serial killer, a guy who chops up his wife can get his phone back in 24 hours. And if they can conduct a 36-page investigation on a guy who had little rubber duckies in the town of Canton, and then Canton, and then go to his place of work, pull garbage from his house, get search warrants for a makestickers.com, and then go to his place of work and put a little text stream data in there to download all of his information from his Toyota truck for littering and for putting little rubber duckies around town. You better make sure that I'm going to have snark about that, because I think that's an abomination of your constitutional rights. And sorry, there's a solution for that. It's called change the channel. Change the channel. There's plenty of the channels that you can watch. I don't care. It doesn't bother me, but it should bother you that your constitutional rights are being trampled all over. So there's that. You don't have to stop and leave a nasty comment. You can just turn the channel. There are plenty other places you can go if you want drama, if you want other things that I'm not pleasing you. If I'm not pleasing you, turn the channel. Thank you, Goodmans. Oh my God, people, quit your ducking, bitching, Mel. You do amazing. Thank you. I also have a child who had a tonsillectomy yesterday. So it's been a week, and I did a stream earlier. So you know what? I'm done. Peace out, everyone. I hope you have a wonderful evening. I hope I hope you're not as procrastinated as I am, and you've decorated your whole entire tree and wrapped all your gifts or lit all the, I don't even know, when does Hanukkah start? Is it the same as Christmas? I know. How dare I give my opinion on my own show? I know. It is so rude of me. Righteous indignation. I'm done with the drama. I didn't address any of the drama tonight. You know why? Because I don't give a duck about the drama. I'm here to talk about what I want to talk about and not what everyone else is talking about. So if you want to talk about what everyone else is talking about, then there are places to go do that. Okay? Okay. Thank you so much. Thank you for playing. Have a nice day. I'm going to come back tomorrow and do the Blake Lively versus Justin Baldoni lawsuit, which is fire on the sexual harassment. I think it's going to be at noon. So make sure you have a subscription. Click that and click the bell and all of that other stuff so that we can go over that tomorrow, because that is going to be crazy. And also, I auditioned for that movie, so it has a special place in my heart. And then so many people gave Blake Lively so much crap for the way she did not promote the movie because it was about DV. They didn't think she was sensitive enough. Blah, 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 blah. I'm interested in it. You guys seem to be interested in it. So do all the things and stuff that YouTube likes. Smash the like button on your way out. Smash the down like button if you're on the way out if you want to, because, hey, engagement, right? Stay cool, stay kind, stay classy. I love the moderators. You guys are amazing. You guys are amazing. I love you with all of my heart. Every single one of you who's nice is, whoa, Grant just posted documents filed yesterday. Lindsay going after Aiden and Bradel. Oh, is that the stuff that was impounded? Thank you, KLM. Did he just post that like just now? The stuff that was impounded, the stuff that we were, oh, hold on. I got to look at that now because we're here. So since we're here and you were sweet enough to put in a super chat without telling me that I was being mean or snarky. Well, I don't see anything. I don't see anything that was just posted. So stop the presses. Stop the presses. Wait, don't go. I don't see it. He's at Grant Smith Ellis, right? The last tweet that I see, maybe he had to take it down. It's from 8 hours ago. And I'm not looking at the parody. I'm looking at the regular account. Can you guys point me in the direction of it? I don't see it. Unless it's the parody account that you're looking at. I don't know. Lindsay is in big trouble. Somebody said 20 minutes ago. He just showed you what I showed you, and then he must have taken it down because I don't see it. He didn't post the documents, but he is confirming apparently that it's about Lindsay. So I'll see it. Oh, thank you. Thank you, Jody. I can't, you can't post links in the chat. I think he took it down. All right, you guys, we'll have to look at it again. We'll have to look at it again. If it comes up, if anybody screenshotted it like you guys always do, email it to me, fanbase@mlittlelaw.com. Love you guys. I'll see you tomorrow. No, it's there. Check his replies. Oh. Hold on. I'm getting frustrated with the amount of pressure I'm getting right now. Didn't know somebody has the Bard of Overseers has a thing. I don't see it, you guys, and I can't. I gotta go. I have a kid who needs me. I apologize, but if we ever find it, he's showing you basically what I showed you. If he posted those things that are impounded, he's going to be in a lot of trouble. So, thanks, you guys. I'll see you tomorrow. Peace.